हेलो स्टूडेंट्स, कैसे हैं आप लोग? होपफुली आप लोग अच्छे होंगे। और क्रिएशन लॉ एकेडमी से हम कंटिन्यू कर रहे हैं उसी सेशन को जहां पे हमने ड्रॉप किया था। सो स्टडी सेशन वी हैव ऑलरेडी डिस्कस्ड एंड some important terms that we discuss today, that is billable offense और non billable offense. Generally what happens कि डे टू डे लाइफ में हमारा इनकाउंटर होता है या हमारा इंटरेक्शन होता है इन दो वर्ड्स के साथ कि बेलेबल और नॉन बेलेबल ऑफेंस क्या है। और सीआरपीसी का जो प्रिलिमिनरी सेक्शन है, प्रिलिमिनरी सेक्शन मीन्स कि स्पेशली फ्रॉम 1 to 5, फ्रॉम सेक्शन 1 to 5 I mean, the very basic chapter of CRPC, Code of Criminal Procedure 1973 or Criminal Procedure Code 1973, okay, in which Section 2 is mainly about definition part. Section 2 is mainly about definition part. और इस definition part में हम देखते हैं कि जैसे offense क्या है, bailable offense, non-bailable offense, cognizable offense, non-cognizable offense, and warrant case, summon case, victim, SHO यानी कि स्टेशन हाउस ऑफिसर, उसका जो बेसिक डेफिनेशन है कि दैट डेफिनेशन कीप्स रिकरिंग और कीप्स अकरिंग टाइम एंड अगेन वाइल स्टडिंग प्रॉपर कोड इन अ रेगुलर सेशन। सो आज ब्रीफली हम समझने की कोशिश करते हैं कि व्हाट इज द डिफरेंस बिटवीन बेलेबल ऑफेंस एंड नॉन बेलेबल ऑफेंस, विच ऑफेंस कैन बी टर्म्ड एज अ बेलेबल एंड विच ऑफेंस कैन नॉट बी, एंड स्पेशली इन कोर्स ऑफ स्टडिंग दिस वुड ऑल्सो ट्राई टू नो कि व्हाट इज शेड्यूल 1, what is schedule 1 and schedule 2, and what is the relation between this code and IPC, I mean ki Indian Penal Code or substantive and an objective law. Most of you are already aware of these terms, so in briefly we are just simply discussing in a very short span of time. Okay, so see the bailable offense. See the bailable offense ki bailable offense is especially mentioned in section 2A of this code, I mean ki CRPC 1973, bailable offense, कि the offense under which you are entitled to be released on bail, you are entitled to get on bail, okay, and moreover in bailable offense you can claim bail as a matter of right, not as a matter of discretion, okay. No. So briefly हम डिस्कस करते हैं इसको कि एज आई टोल्ड यू कि अंडर सेक्शन 2A ऑफ दिस कोड, कोड ऑफ क्रिमिनल प्रोसीजर, इट हैज बीन डिफाइंड दिस बेलेबल ऑफेंस. So some of the basic constituent or some of the basic component we'll discuss one by one, and what is the relation between bailable offense and non-bailable offense would also discuss. Okay, so let's understand one by one. Especially in the last lecture that we discussed about the strategy, exclusive session was on strategy session related to CLAT or some other NLUs, law related entrance exams, including Delhi University or DU. And last lecture we discussed about the strategy session of Judiciary. As everyone knows that there are a number of papers, so how to prioritize or how to strategize your preparation, what are the major acts or what are the minor acts, even we discuss in detail. So in regular session we'll be doing in a very regular fashion, in a very regular way, but especially in some sporadic session we'll try to discuss and understand the important terms that we generally get encountered in day-to-day life, या जिसकी information हम सबको होनी चाहिए as being a law graduate और non law graduate. Bailable offense क्या है? अक्सर हम कहते हैं कि नहीं कि इसमें बेल हो सकता है, इसमें बेल नहीं हो सकता. What does it mean? What does it truly signify for? Okay, so let's see. Whenever we say that is a bailable offense means कि certainly कि there has been some consideration or there has been some ingredient. That generally we say कि the offense that is punishable up to 3 years or less than 3 years, we are entitled to, not we are means कि we have not created or committed an offense, but in general कि we can get a bail. And in non-bailable offense that is generally considered a serious in nature, or grave in nature, and punishable beyond 3 years or more than 3 years. And in exceptional, in some special cases, 2 years or more. In next lecture, we'll discuss about warrant case, summon case, cognizable offense, non-cognizable offense, and many more things. So whenever the very term this bailable offense comes, so before discussing in this particular sentence or this particular word, we'll try to understand what is a bail and some additional terms. If I say bail, बेल के साथ कुछ इंपॉर्टेंट टर्म्स आते हैं जिसके हम लोग फरलो, व्हाट इज फरलो, व्हाट इज पैरोल एंड अदर रिलेटेड टर्म्स, So in course of doing so, be it bail, be it furlough, or be it parole. So in course of studying this or discussing this, even would try to understand this Probation Offenders Act. Probation of Offenders Act. That is also a part of most of the state laws. So we'll discuss in a regular session there. So especially whenever we talk about bailable offense, it clearly indicates that it has been defined under section 2A of this CRPC, I mean ki Code of Criminal Procedure. And bailable offense means ki the offense under which you are entitled to be released on bail. You can get a bail as a matter of right, not as a matter of discretion. But contrary to bailable offense, in non-bailable offense we cannot get bail or we cannot secure bail as a matter of right, but it is subject to discretion of court. Subject to discretion of court means simply ki discretion of concerned magistrate or concerned judge. Okay. So some of the essential component or essential ingredient we'll discuss. If I say the offense that is less serious in nature, offense that is less serious in nature, offense that is less serious in nature, in bailable offense, especially mentioned in Schedule 1. Schedule 1. As we know that there are two schedules in CRPC. The Schedule 1 is about classification of offense and the Schedule 2 about forms. Number of forms are there, especially aggregate number is 56. पीटी में भी क्वेश्चन पूछ दिया जाता है कि शेड्यूल 2 के अंदर में कितने फॉर्म्स अवेलेबल हैं या कितने फॉर्म्स मेंशन्ड हैं. क्लियर है? तो शेड्यूल 1 में जो स्पेशली जो बेलेबल ऑफेंस हैं उनके पूरा का पूरा लिस्ट दिया गया है. उनमें से सर्टेन एग्जांपल हम दे सकते हैं. फॉर एग्जांपल राइटिंग, अगर कोई राइट करता है वो, गिविंग फॉल्स एविडेंस and even forgery and something alike in nature that are truly less serious in nature. And moreover, so especially the offense that are mentioned under Schedule 1 as a bailable offense, we can claim bail or we can secure bail as a matter of right. It not necessarily that we can get bail in practical life or in practicality. So theory and practical is entirely different. Okay. So as I told you, especially under 2A, the offense that has got mentioned in section 2, this Schedule 1 of CRPC, some example I already told you, and some essential component like less serious in nature, punishable up to 3 years or lesser, punishable up to 3 years or lesser. Okay. And we are entitled to, the person who has committed a crime, he is entitled to be released on bail, and moreover we can claim bail as a matter of right, we can claim bail as a matter of right. And one general perception is that especially when under bailable offense, when bail you can claim as a matter of right, so in that condition you cannot go for anticipatory bail. But in theory and practice, or different perspective or different perception we do follow. So one more point we can add, that anticipatory bail is unavailable. Anticipatory bail unavailable in case of bailable offence. Clear है? Anticipatory bail is unavailable in case of bailable offence. So in a very concise way, we can say bailable offence has got mentioned under 2A of CRPC. I mean 2A of this code. Whenever we refer code, it simply indicates that Code of Criminal Procedure. Okay. So the definition has got under 2A, and some essential component, some special ingredient like less serious in nature, punishable up to 3 years or lesser than 3 years. Offender is entitled to be released on bail, or he can claim bail as a matter of right. But contrary to all this means कि from 1 to 5. From 1 to 5. If I say in non-bailable cases, so non-bailable case means कि more serious in nature. And accordingly we can advance so far. And not entitled to be released on bail. Not entitled to be released on bail. Not entitled to be released on bail. And moreover, we cannot claim bail as a matter of right. So matter of right, if you cannot claim, it simply indicates that it is a discretion of magistrate or discretion of the court. Discretion of court or magistrate. Okay? And the third one is, because you cannot claim bail as a matter of right, so in that condition one can go for anticipatory bail. नहीं, क्या कहते हैं एंटीसिपेटरी बेल को? ना, अग्रिम जमानत. तो अग्रिम जमानत we can ask for, or rather अग्रिम जमानत can be sought after. Okay. And generally punishable beyond 2 years. Beyond 2 years. Or in briefly if you can say कि in warrant cases, the provision mentioned under warrant cases, including life imprisonment and death penalty. So once we understood this, the basic component or basic ingredient under bailable provision, bailable offence, it has got mentioned under 2A of the code, and second, whatever the offence mentioned under Schedule 1 is a bailable offence. And bailable offence generally means less serious in nature. Offender is entitled to be released on bail. Offender can get or can secure bail as a matter of right. Generally the offence punishable up to 3 years or lesser than 3 years. And because one can claim bail as a matter of right, so there is no provision for anticipatory bail. Clear है? और जितना हमने बताया आपको बिल्कुल इसको उल्टा कर देना है इसमें नॉन बेलेबल ऑफेंस में. और इसी कंडीशन में बेलेबल ऑफेंस के साथ में अब आप हमको कमेंट करके बताएंगे कि क्या क्या आपको करना है या क्या क्या चीजें आपको पता है कि बेल से जुड़े हुए फरलो क्या है, ये आप देख के बताएं मुझे. फिर साथ में परोल क्या है ये भी बताएं, और स्पेशली इन द वेक ऑफ इन द लाइट ऑफ प्रोबेशन ऑफेंडर एक्ट, स्पेशली 2 टर्म को. और अगर दिक्कत होगी तो आप मुझे रेफर करें ताकि फिर हम अगले सेशन में इसको हम कंसाइज वे में हम बता सकें. और बाकी रेगुलर सेशन में हम लोग डिटेल में करेंगे. और इसी कंटेक्स्ट में एक इंपॉर्टेंट केस है जिसको हम लोग नेक्स्ट सेशन में डिस्कस करेंगे. तलत हाजी हुसैन 1958 का कोर्ट का क्या ऑब्जर्वेशन है इसमें ब्रीफली आप एक बार देख सकते हैं कि व्हाट इज तलत हाजी हुसैन केस 1958 एंड व्हाट इज अ जनरल ऑब्जर्वेशन, जेन्युइन ऑब्जर्वेशन ऑफ द अपेक्स कोर्ट related to bailable offense or non-bailable offense. Is it directly related to that offense or not, or related to cancellation of bail? So we'll discuss in detail later. So hopefully this brief session would be beneficial for you, and accordingly next session में हम कोशिश करेंगे कि bailable के साथ साथ non-bailable को concisely करते हुए फिर हम cognizable, non-cognizable, victim, warrant case, summon case, and this station house officer, victim, and some other important terms defined under section 2 of the code. We'll discuss thereafter. Okay. तब तक अपना ख्याल रखें, स्टडी करते रहें आप और कमेंट करते रहें, और अच्छा लगे तो आप इसको लाइक करें, सब्सक्राइब करें और आगे प्रोसीड भी करें।